Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages.
Yes, Owens, we know.
It's based on the evidence at trial.
But what's the overt act? My question really is, what's the overt act by the victim that an overt act is needed? What is the overt act?
In the overt acts, I have to tell you, his hand is coming out of the suitcase.
I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since we have some level of common ground here?
My case is not going to be presented, I would assume, until next week, so I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
The decedent no longer had his own phone and was using Miss Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being admitted?
State conceded they need to lay the appropriate foundation. Well, part of their, and we need to establish deadlines to prevent any ambush or last-minute issues. Then y'all parachuted in on August the 30th.
Parachute in?
Yes.
There was no order, there was no request to vacate any of those deadlines.
I didn't nap, so I'm back. We're going to do a recap of today's hearing. They're still in day 3 of jury selection. I'm not sure when opening statements is going to happen, but let's talk about today's motions argument. Now, arguments, plural. It was a little rough for the defense. They did outright win one of their motions and then partially won some of their other motions. But like I said, it was a little bit rough with the defense, lots of back and forth with the judge. However, now we have not just Mr. Owens making the argument, we also got the other attorney, Mr. Henderson. And Mr. Beck, the third attorney, is somewhere in the back, but he didn't participate in the arguments today. Maybe we'll hear from him later on in the trial. Not quite sure what he was doing sitting all the way in the back, though, of the courtroom. So here's what we got. We're first starting off with the battered spouse syndrome defense. The state wants to have that completely excluded. They said that Dr. Julie Harper had a examination of Sarah Boone over, the past 5 years. And with the most recent one, when Sarah Boone gave her details, well, the state had issues with it because the state says it doesn't seem like this is self-defense. It seems like Sarah Boone, initially she said it was an accident. However, they're not saying that now. That's what Mr. Owens said. He made that quite clear. But now it seems like Sarah Boone admitted to some of the things. Now I'm going to read the motion. And then if y'all want to skip over to the video part, I'll have the timestamps in the below. Oh my God, my earring was dangling out. Jury selection was supposed to start last Monday, but that got delayed because of the hurricane. During that time, Sarah Boone also was given a plea deal, which she rejected, which is kind of odd because she already has about almost 5 years of credit for time served. And I think they offered her 15 years. Now, I don't know if she would have qualified for good behavior or some sort of early release program or supervised release program or something like that. But I'm like, excuse me, ma'am, you're facing 22 years minimum, but you're facing up to life. And, 15 years and you already did about 5 years. That's not that bad. The videos, and she even, okay, here's the thing. How are you going to reject a plea deal when you filmed yourself doing the crime? But Sarah Boone came in for jury selection day 1. And I'm like, what is she wearing? She looks exactly, the outfit that she wore was this blue top and it looks exactly like her jail outfit. Feel free to join the Discord. We do have a true crime section. If you guys want to discuss this case or other cases, feel free to discuss it in there. And then we also have non-true crime section stuff in there as well. So this is Sarah Boone. That looks exactly what she was wearing when she was in her prison or jail outfit. It's the same shade of blue, but it's got a little neckline right there. Okay. But to me, I thought it looked the same. I was a little confused, actually. At first, I was like, oh, did they not give her normal clothes to wear?
You told me last week that you were ready for trial. Are you ready for trial today?
I am.
Okay, all right.
The suit looked odd on her. I think she looks better in the suit, in the little suit thing that she has on. The power suit? Oh, I saw it at a glance, and I thought it looked okay on her. Her hair looks a little bit rough, and she does need to button up all the way. Maybe it was really hot in the courtroom or something. I don't know. Sarah Boone, attorney fist bump during jury selection. Sarah Boone and her attorney appeared to give each other fist bump ahead of a second day of a jury selection and second-degree murder trial. Boone is accused of second-degree murder in the death of her boyfriend, Judge George Torres. Torres was found dead inside a suitcase.
The snacks that Sarah Boone is requesting to have in the courthouse with her. So at the end of the day today, Sarah Boone's attorney asked the judge for Sarah Boone to have 2 juice boxes, 2 bags of chips, 5 peppermints, a bag of candy, and a bag of Pop-Tarts to get her.
What the fuck? Oh my God, what is wrong with Sarah Boone? Jesus. Can I please have my Lunchables and my Capri Suns, but make sure it's like the tropical fruit flavor, okay? That's the only one that I like to drink and eat.
Through these court hearings, she says she needs that to keep her energy high. She's been in court for the last 2 days.
Or just eat regular lunch, eat breakfast. We got the full medical examiner file. So this is filed by Mr. William J. So pages 921, 981. Now, the full ME file, I'm assuming that's for George. And I'm assuming ME stands for medical examiner, right? Do you think it stands for anything else? Does anyone know? All right, now we got the state's motion in limine to exclude the battered spouse defense. Or exclude mention of battered spouse syndrome evidence until the defendant justifies to a justified use of deadly force. I think the state already put in a motion like this and that was denied by the judge, but I guess the state is putting this motion again because now they have their own expert to evaluate Sarah Boone. Let's see what the judge says. Introduction. The defendant has filed a notice and an amended notice of her intent to rely on battered spouse syndrome evidence in this case. Number 2. Battered spouse syndrome is not actually a defense to a crime. The introduction of battered spouse syndrome evidence to support a self-defense theory is not for the purpose of justifying a defendant's misperception of reality or to explain why unreasonable belief was nonetheless justifiable due to her condition. Rather, the Florida Supreme Court has sanctioned the use of battered spouse syndrome to show why the defendant's actions were reasonable. To show in spite of a reasonable perception of danger from the battering spouse, the battering defendant would remain in the home with her batterer where she may resort to the exertion of force against him to prevent imminent threat or great bodily harm. Here are the facts. 3. The defendant has presented several accounts of what happened on February 23rd, 2020. She made a 911 call at approximately 1 p.m. on February 24th, 2020. And remember, the parole officer was like, or sorry, the parole deputy was like, so you said you're awake in the morning and you found him in the morning? Why did you wait so long to call us now? And Sarah Boone's like, Sarah Boone spoke to a patrol deputy on body-worn camera shortly thereafter, providing a statement to detectives a few hours later on February 24th, 2020, and provided a second statement to detectives on February 25th, 2020. Let me just check on... The defendant retained Dr. Julie Harper as one of her battered spouse syndrome experts in 2020. Over the course of the next several years, Dr. Harper interviewed the defendant about the events of February 23rd, 2020 multiple times. Exhibit A at the hearing on this motion will be Dr. Harper's deposition, which was taken October 1st, 2024. The state would direct the court to pages of Dr. Harper's deposition for the defendant's statements about February 23rd, 2020. The state retained Dr. Tanya Warner, this is the state's expert, as his battered spouse syndrome expert. Dr. Warner evaluated the defendant on October 2nd, 2024, and Dr. Warner was deposed on October 4th, 2024. Exhibit B at the hearing on this motion will be Dr. Warner's deposition. The state would direct the court to pages 75 to 79 of Dr. Warner's deposition for the defendant's statements about February 23rd, 2020. 6. The state is not asking the court to make any credibility determinations about the defendant's statements to the doctor. That will be for the jury to do. In the full context of a cross-examination with the defendant's statements to law enforcement. 7. What the state is asserting is that, as a matter of law, that the defendant told the doctors does not entitle her to a self-defense instruction, nor does it entitle her to introduce evidence of prior instances of violence, reputation evidence of the decedent's violence, or battered spouse syndrome evidence to help the jury understand why what she did was objectively reasonable. Number 8, the defendant told the doctors that because of past violence between her and the decedent, she had a generalized fear every day that the decedent would cause her serious bodily harm or kill her. 9, however, on this particular day, the decedent did not take an overt action, even the slightest, that made her believe he would cause her seriously bodily harm or death. According to the defendant, where she and the decedent woke up, the decedent wanted to drink alcohol. She did not. So in order to distract the decedent, she suggested that they instead clean the defendant's townhome, which they did. 11. At the conclusion of the cleaning, the decedent still wished to consume alcohol, so the two of them began consuming alcohol. The defendant did not want to consume alcohol, but she did so to placate a decedent. Yeah, I don't know if I believe that. Yeah, I don't know, because people be saying Sarah Boone was also a drunk as well, man. Number 12. The alcohol they consumed was a Chardonnay bottle by Woodbridge. Oh, I know Woodbridge. I know that brand. In order to prevent the decedent from becoming sad or upset, she kept him diverted by smoking cigarettes with him, drinking, enjoying each other's company, perhaps using the dartboard on her porch and doing arts, crafts, and puzzles in hide and go seek. Although it apparently would upset the decedent, the defendant suggested he call his daughter, who did not like talking to him when he was drinking, or that he call his brother to tell his brother that the decedent had dragged the defendant down the stairs the night before. Dragged the defendant. And you remember what Sarah Boone kept telling the interrogators? We haven't fought. We haven't fought for a while. Things were good. Things were good. 15. Having done these playful activities for numerous hours, there came a point where the defendant and the decedent were sitting on the couch in the downstairs living room, and the decedent tagged her and said, "You're it." Oh God, so cringe. Okay. From past games of hide and seek, the defendant understood this to mean that he wanted to play hide and seek. I don't know. She talks about George like he's like a fucking child. She begrudgingly engaged in this game, as with everything else, to placate the decedent. She ran up the shower. After becoming cold, perhaps some misunderstanding about the rules of hide and go seek, she left the showers upstairs and returned downstairs to find the decedent placing himself in a suitcase to hide. At the time of the death, the decedent was only 103 pounds. Really? George was only 103 pounds? And had a blood alcohol level of 0.138 grams per deciliter. Can they convert that for us? The defendant saw him doing this and decided to zip in the suitcase shut while the decedent was inside it. They were both laughing, and there was still no animus between them on this day. The defendant says she did not zip it completely shut. The decedent was able to poke a couple of fingertips through the gap left by the zipper. Just sounds like all lies, man. And then the decedent said he could not breathe. The decedent obviously got mad about not being able to breathe. The decedent getting mad made the defendant get mad. This reminded her of past violence the decedent committed against her, causing her to be unable to breathe at those times. This made her angry. The defendant shook the suitcase. She lost control, and the suitcase flipped. Okay. But the suitcase still had a 103-pound man in there. You would have to, like, forcefully flip him over. It wasn't like you're just like shaking it and then, oh my God, it accidentally flipped over. Oh no. She hit the decedent's fingertips with a wooden baseball bat that was in the room. Holy shit. So she admitted to hitting him with a baseball bat? Because remember, the detective, when they were confronting her with the autopsy report, was like, hey, like there are some bruises on George. He had bruises on his like head. He had like his head right here was like swollen up. She admitted to hitting him with a baseball bat? I thought she was going to deny that part. Because, you know, even though she's only saying that like, oh, I hit him with a baseball bat and it only hit his fingertips, people aren't going to believe that. They're going to think that you're minimizing what you did. Holy fucking shit. I can't wait to hear this, this evaluation that she did with the mental health person. Now, after having committed the independent forcible felonies of aggravated assault, aggravated battery, and the non-forcible felony of false imprisonment, the defendant believed the decedent would kill her. Despite believing the decedent would kill her, the defendant flipped the suitcase over so it was right side. Oh God, she admitted to doing all of this. Oh, this, holy shit. Seriously, I thought she was just going to deny everything. I mean, we have it on video in the pictures where the orientation of the suitcase was different. But I thought she was just going to be like, oh, George did it himself. He was struggling to get out and he just flipped himself, you know, while he was in the suitcase. Despite believing the decedent would kill her, the defendant flipped the suitcase over so it was right side up and she believed the decedent would be able to let himself out. The defendant's specific intent was for the decedent to feel what it was like for her to choke and not be able to breathe. She intended for him to feel this for 2 minutes and she believed he would let himself out. And when that happened, if she died, she died. Oh, like Sarah Boone. But she didn't let him out though. 22, she did not intend to kill him. She did not believe that leaving the decedent in the predicament she placed in would kill him. His death was an accident. Jesus. This is so bad. This is so bad for her. Legal analysis. Battered spouse syndrome evidence is inadmissible if the defense is an accident rather than a self-defense. And remember, they were going back and forth. They were like, the judge was like, did you say it was an accident? And James Allen's like, no, what do you mean? It's not an accident. The defendant's testimony is that she intentionally zipped the suitcase out of levity and while kidding around with the decedent during a friendly game of hide and seek. Then when the decedent informed her, God, man, for people who do not know shit about the Sarah Boone case, and then they're the jury sitting in there, they're going to be like, what the fuck am I, what is this? You're telling me I took off work for 3 weeks to sit in this trial about this woman who was claiming that she played hide and go seek, claims that the victim zipped himself up in the suitcase? Oh my goodness. They're in for a real shock. I mean, we've been dealing with this for about 4+ years now, 4 or 5 years now. And then oh God, for them, it's going to be a real shocker if they've never heard anything about this case. The defendant's testimony is that she intentionally zipped the suitcase out of levity while kidding around the decedent during a friendly game of hide and seek. Then when the decedent informed her that he could not breathe, she intentionally decided out of anger to make him feel like he's trapped in there for a couple more minutes while she beat and shook the suitcase and hit his head with a baseball bat. This is aggravated assault, aggravated battery, and false imprisonment. She stated that she flipped the suitcase right side up, saw the decedent could get 2 fingertips through an opening. She went upstairs to bed believing he would be able to get out in a couple of minutes. But here's the issue. He never appeared next to you by the bed. If you really thought that he was pissed and he was going to come after and kill you, why would he not come after you then? Obviously, he didn't get out of the suitcase because he didn't come after you. He wasn't in, and if he was in a good mood, he didn't come and sleep next to you. What did she think, that he was just going to be downstairs and just chill downstairs on his own? No, she knew what she was doing. She had no intention to kill him, no intention to leave him trapped inside the suitcase. She did not even comprehend that he could die from this. The defendant is thus still saying that the decedent's death was an accident, and she's not entitled to instruction of self-defense or to supplant a self-defense case with reputation evidence, specific instances of past violence, or battered spouse syndrome evidence. 24. The defendant, I don't know what she's thinking. I don't know what she was thinking. She thinks this makes her look better. How? How does she believe this? I don't understand. What is her mindset? 24. The defendant's statement that she perpetually lived in the state of fear of the decedent is not sufficient to allow for self-defense instruction, and all of the ancillary evidence of reputational testimony, specific acts of past violence, or battered spouse syndrome testimony. However, before a defendant may introduce evidence of a victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Let's see. Victim hit defendant with a 2-inch wide, 2-foot long stick in the hand, causing only minor injuries, did not justify defendant's use of a deadly force. Comparing the facts of this case, it is clear that there was not even the slightest overt act by the decedent in this case. Prior to the defendant committing aggravated assault, aggravated battery, false imprisonment, there was no imminent threat from the decedent. You can't just attack somebody as they walk through the front door and slash their throat with a knife because 2 days prior they sent you a threatening text message. 26. If this evidence is improperly admitted, it would be a departure from the essential requirements of the law that would result in irreparable harm that cannot be corrected by the post-judgment appeal. The state acknowledges the defendant is entitled to change her story yet again, so if the court does not exclude this evidence now, the defendant should be barred from mentioning battered spouse syndrome evidence until the defendant testifies to something that is justifiable use of force. Yeah, she might go up there in the stand and make up something else. Battered spouse syndrome evidence properly excluded until defendant testifies that the only source information for the defense. Not improper to exclude expert testimony until the facts are in evidence. Battered spouse syndrome not available if the defense is an accident rather than self-defense. Holy, I can't believe she admitted to this. I really didn't think she was going to admit to the whole baseball bat thing. So I kept hearing people saying that, oh, she beat him with the baseball bat. She beat him with the baseball bat. And I was like, I don't know. I don't know if she did or not. I don't know. I have no idea. And then when we heard about when I listened to the interrogation again, and then they mentioned all the bruises and he had basically a ball on his head, oh, wait a second. Maybe she did. So let's listen to the state's in-court argument today.
Your Honor, this is a motion in limine. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, given that her latest version of events was just given to our expert last week. If that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. Because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony is we were having a good day. We were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing. We're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually it comes to a point in time where they're sitting on the couch and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes is nearly entirely shut, but 2 fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time. When he starts to say, "I cannot breathe," now she describes to the doctors that she does have bad intent. And she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer.
And we read the state's motion where Sarah Boone admitted to their expert that she hit George with the bat while he was in the suitcase. However, she said, "Oh, I hit him just where his fingertips were." No, you didn't. You hit him everywhere, okay? It was bruises all over his head, his face, and stuff like that.
But she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out, and she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So she should have to testify before any of those things come in, and her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony.
Who's going to argue, Mr. Owens or Mr. Henderson? Oh, Mr. Henderson. I'm glad that we can hear Mr. Henderson today, because before, when he was arguing on that voice conference thing, we couldn't hear shit.
I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective. Concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense, until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please Correct me if I'm wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
It seemed pretty clear. The state's not talking about voir dire. The state's not limiting it to just opening statements.
Judge, if I could have you repeat that question.
Sure. So my understanding, well, let me ask you, I'll have a more of an open-ended question. What is the basis, factually, of Dr. Harper's opinion? So if we were at trial right now, for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step 1 under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion.
But based on the Akendo case, which is cited by the state as to what what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
Yes, but this is the problem that I'm having here. Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions.
Mm-hmm. So what the judge is asking, what did George do? What was the overt act that George did that caused Sarah to believe that she was in imminent danger? And because I'm sure when Sarah told Dr. Harper probably was like, you know what, you're right. I don't really know what was the imminent danger because George was in the suitcase. So I'm not surprised that Dr. Harper was struggling to answer the question. Now I wonder how she's going to do when she testifies.
So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but it has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented.
That sounds like a, I don't know. That sounds like a, I don't know. Okay, the judge is interrupting because we're also like, what is the overt act?
At trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's 2 avenues in this motion. Avenue 1 is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
And if you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is...
Would it be better to have Owens argue this then?
What does Ms. Boone, in this case, testifies to on the stand? And if any of that... excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there.
That's why I was like, why is he arguing it then? We'll get Owens to do this.
But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't
I feel like we didn't need the dog analogy. He could have just kept it at storage.
want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know, based on the court's ruling, what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So That's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence.
Because I think if you're saying it in front of the jury and you wanted to like dumb it down a little bit, maybe use analogies like that, but the judge knows. You don't need to use the dog analogy for the judge. But, you know, I get what he's trying to do, but it's not unnecessary for the judge, in my opinion.
Is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting.
Needs to dumb it down for the defense. Oh, okay. Okay, maybe that then.
So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in.
Yeah, and motions to eliminate changes all the time because, you know, initially when you're making a ruling, you're like, okay, well, you're not allowed to say X, Y, and Z. And then as the trial unfolds, sometimes it's like, okay, well, actually, you know what? There was an open door for this. We're going to introduce this. There's an open door for this. We're going to introduce that, right? So with the Murdoch trial, remember how they weren't supposed to introduce the financial crimes and they weren't supposed to introduce the roadside shooting. They determined that all, and I think in motion eliminate. However, as the trial was happening, well, it seems like the defense opened the door for that. And that was when they were able to introduce all the stuff that was supposed to be excluded initially. So he's saying that, like, you know, let's make the ruling now. But however, as the trial progresses, you know, maybe the motion eliminate will be, I don't know, reverse, I guess. Now, let's listen to the defense and see if they finally answer what the overt act was. They do.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act, based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
yes, sir.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now.
You can't say it's not and then not explain why it's not. It's just not. It's just not. Okay, how?
To disclose what our view of the overt act is. That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase.
What?
That means
No.
he's about to get out of the suitcase.
No.
Now, based on history,
You mean after she zipped him up, after she hit him with the bat, the overt act is him sticking his fingers out of the suitcase, which I don't believe, by the way. I don't believe he was even to stick his fingers out of the suitcase.
and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence, because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The State's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling?
Court's ruling?
I'm sorry, the court's ruling, forgive me. Defense.
Meaning?
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire, and even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
My concern is opening. Can it be mentioned in the
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you.
Okay, that was I don't know, his response to that with saying, because before he couldn't answer what the overt act was. The judge was like, what is the overt act that was committed by George Torres that day? And they didn't respond. They're like, we don't know. I don't know. I wasn't even there for the deposition, actually. Owens was there. It's like, okay, then why are you doing the argument? And then so he said that, okay, well, in order to know what the overt act was, Sarah Boone has to go up there and testify. And the judge was like, what is the overt act? He basically didn't know. And then when he was really pushed to a corner, he was like, well, the overt act could have been George sticking his finger out of the suitcase. At that point, maybe it was really threatening that his fingers were coming out of the suitcase. And that we can tell because, at that point, his fingers were bruised up because Sarah Boone hit him with the bat. Sarah Boone, somehow George got in the suitcase. So don't know how, right? George got in there. Maybe they were zipping each other up. That was funny, whatever. But he got in a suitcase. He wasn't able to get out. And she admitted to the expert that she beat him with a baseball bat while he was in the suitcase. He had no way to come out. She claims that his fingers were sticking out and then that she beat his fingers. I don't know if I even believe the fingers were even coming out. But how could they say that was the overt act? Oh, the fingers were coming out of the suitcase. He was still in the suitcase. He was still in there. Oh my gosh, so crazy. So basically, the judge said that the battered spouse defense, whatever it is, the state wanted it to either be completely excluded, but the judge was like, no, we're not going to do that. So that was denied. However, the other part of the state's motion was, well, until it is shown that, there might be a reason for self-defense or something like that, then later on, maybe the expert can bring up battered spouse. But we'll have to see what happens with Sarah Boone's testimony. So the judge says that, okay, well, you could bring it up in opening statement defense. If you want to bring up battered spouse in opening statement, go for it. However, your experts can't bring up battered spouse unless something arises to the point where it shows that, okay, well, maybe there is a self-defense here somewhere. But I think we would have to wait for Sarah Boone to testify first. Or maybe through other testimonies, it'll come through. I don't know. We'll see. I don't know, man. When he mentioned the fingers coming out of the suitcase, I was like, what? No way. So I wonder if the defense, if they're going to stick with that the overt act of George sticking his fingers out of the suitcase, maybe trying to get out, that was what caused Sarah Boone to be in fear of her life. Maybe they'll stick with it. Or maybe they'll adapt it in some other way. Next motion is to exclude statements made by law enforcement during the interrogation. Here is the written motion from the state, and then we'll listen to the arguments. Defendant was asked to come to Orange County Sheriff's Office. Defendant arrived on February 25th, 2024, was escorted to the interrogation room. Actually, maybe I did read this. A custodial interrogation defendant then ensued. The approximate 2-hour interrogation was recorded by audio and video. During the interrogation, the two homicide detectives questioned the defendant at length concerning the facts and circumstances surrounding George Torres' death. At such time, statements were made by the defendant and the two detectives. Some of the statements made by the parties should be excluded and redacted from the video mentioned above. I think, did we read this? This looks different, actually. Maybe we didn't read this with you guys. From the transcript of the video entitled, Transcript of Tape Interview of Sarah Boone conducted by Detective Chelsea Kepsel, case number 20-17904. The first section of evidence to be excluded. The following dialogue from pages 69 through 71, beginning on line 6 of page 69. Detective Scott Lowen. Hold on. You had two different neighbors that lived directly next to you. You asked to use the bathroom. They told you no and turned you away. You had to go, ... Sarah Boone. Oh. Detective Scott Lowen. Across the way to somebody else. Sarah Boone. Oh, no. Okay. Kim and Eli. Eli or Kim is not a nice person. I remember this. Scott Lowen. Okay. Sarah Boone. She's just automatically not nice. Not even after me and Lucas went over there and introduced herself. She's just not a nice person. Sure, Sarah. Sure. Detective Scott Lowen. Then why would you think she would let you use her restroom? Sarah Boone. Because Eli was in there. Eli comes over and talks to us sometimes, which I think pisses Kim off. Oh, maybe she thinks like a jealousy thing. I don't know about that, Sarah Boone. Detective. Okay. Sarah Boone. Because he comes over and talks to us, the two of them. They're like super standoffish all the time. My neighbors down the street, down the way, their toilet was broken. They have stuff in the bathroom. So then they're ... Detective Lowen. Bathrooms. Like taking the notes down. Taxi, thank you so much for the 249. Thank you so much. I appreciate that. Thank you. Okay, so why are we, what is going on here? This is just like stuff that's like irrelevant and they just want this to be excluded. Sarah Boone, like go over there and try over there. Detective, there's two bathrooms, so both are bathrooms. Sarah Boone, I wouldn't let nobody go upstairs and use my personal bathroom. That's what the downstairs one is for. Scott Lowen, or somebody you knew. Sarah Boone, they're in the process of doing all this stuff in the kitchen. Okay. And there's stuff in the bathroom and the toilet doesn't work. Just move across the way, no problem. And of course, they let me in. Them and them, they're together. They're part of their families. That's what you really want to know. And I hope it doesn't get them in trouble, but he's over there illegally. So he's trying to work on getting his green card. Oh, hold on a second. Was this part cut out? I think this part was cut out because I don't remember any of this stuff. I do remember the bathroom stuff and her talking about how Kim was mean and Eli and whatever. Okay, I don't remember all this stuff. Scott Lowen, what has that got to do with you using the restroom? They didn't want to be involved. What's the address? No. I was asking last night because, we had several different people. Sarah Boone, assuming Scott Lowen, stay in the neighborhood, come up. Sarah Boone, Eli and him. Scott Lowen, saying that she was drunk on a regular basis. This part I remember. Sarah Boone, Eli and Kim. Okay, did you ask Benny next door? Those are the ones next door that she asked to use the restroom and they said no. Detective Lowen. Okay, she said no. Detective Chelsea Kupsel. Okay. Sarah Boone. Like I said, she's not a nice person. The second section of evidence to be excluded. Detective Kupsel. Well, he's dead as a result of your actions. Detective Kupsel. He's dead as a result of your actions. Sarah Boone. I understand that. Detective Scott Lowen, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone, I thought about that. Detective Scott Lowen, well, intentions or not, George is dead. You act like when you say unintentionally, that absolves you from everything. She sure does. All right, so Mr. James Owens wants all of that to be excluded. The above evidence is improper opinion testimony by law enforcement officer. In addition, said statements assume the truth of contested facts and encourage the jury to find the defendant guilty as charged because law enforcement officers said so. I mean, it's also how your client responded to it as well, though. If this opinion and evidence is admitted, the jury may assume the validity of the law enforcement officer's opinion because it was allowed in evidence and relied on the opinion in finding the defendant guilty. I mean, I think the judge can just order the jury, be like, hey, this is going to be entered into evidence. And just because it's law enforcement saying it doesn't mean it's true, right? You guys have to make up your minds on your own. The issue of causation is exclusively the jury's job. The opinion evidence invades the province of the jury's fact-finding mission. All right, so he wants that to be excluded. Mr. James Owen. Here's the state's response to the defendant's motion in limine. Number 1, the state does not object to the defendant's request regarding pages 69 to 71. The state does not object to the defendant's request regarding pages 53, 55, 56, 92, Bush v. State. The statements are designed to elicit responses from the defendant, and they did. They are not statements regarding the law or the ultimate issue of fact for the jury. At issue is whether the death was an accident, as she continually insists is the case. even as recently as October 1, 2024, not whether she caused his death. Number 3, the defendant can request the court to read the Florida criminal jury instructions. That's what I was saying. It reads as follows. You're about to watch a recorded interview that contains opinions and statements by Detective Kepsel and Lowen to Sarah Boone. These opinions and statements are pertinent only to explain the reactions or responses they elicit. You are not to consider these opinions and statements by the police officer as true, but only to establish a context of Sarah Boone's reactions and responses. That's what I said. I was like, the judge can just read them in instruction.
Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed to my understanding.
Oh, I didn't consider that, mailman. No, she bops him on the back of the head with a bat. Hence the bat marks on his head. Stuffed him in there and got him trapped, then taunted. I didn't even think about that. I was thinking they were just joking around and then he jokingly got into the suitcase because they were just messing around and just like drunk and just being dumb. I didn't even think about her like hitting him and then like putting him in there. Maybe.
Understanding in their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she had recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that.
Well, my understanding was before he wanted to have the 2-hour interrogation video excluded completely. This argument is now saying that, well, I want to have pieces of the 2-hour interrogation to be excluded, such as the detective saying, you know, he died because of you, right? And then Sarah responding, yeah. Or the other detective saying, you know, this wouldn't happen. Fuck, what did he say again? It was like, he would be alive today if it wasn't for you or something like that. I don't know. So he's saying that statements made by law enforcement, it could prejudice Sarah Boone because if the jury is listening to, oh my God, law enforcement is saying this, it must be true. He's saying that all these statements should be excluded. However, I was like, well, the judge can just tell the jury, hey, you're about to watch this interrogation video. Anything the law enforcement says is not fact, okay? You guys are the fact finders. You guys have to figure out if Sarah Boone is guilty or not. You can't just take law enforcement's word for it.
Page 53, line 11. Well, he's dead as a result of your actions. And then paragraph 9, line 13. He's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24.
Yeah, she acknowledges it.
I have one last question. You realize you're the person that killed him, right? Sarah Boone responds on page 56. I thought about that. And then lastly on page 92. Well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from.
But he's interrogating her. He's interrogating her. He's just trying to get a response from her. It's not like he's testifying on the stand right now and saying, jury, she's fucking guilty. He would be alive today if it wasn't for Sarah Boone. It's not like he's going up there and testifying that.
Law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
So Owens, he does win this one with the judge, and here's the judge's reason. I actually just thought they were just give them instruction, the jury instruction, and like say, hey, you're about to listen to this, and anything the law enforcement says, don't take it as the truth. Okay? But I guess that's not enough.
All right. Thank you both for your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response, that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion, as under the Bush case cited by the state. Law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is this expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from.
What about
I
her
apologize.
response?
Thank you. The defense's motion is granted for those reasons.
Now let's talk about the 550 pages that the state received in discovery about, I think, 2 nights ago. And the state's like, there are 550 pages of these medical records, and we see some that might be relevant, but most of it does not seem relevant at all. We'll get to the defense's argument, I think, right away, because I think the defense was also saying, well, we don't really know either, Judge, but can you give us some time to think about it? Tonight, the state received 550 pages of medical records regarding medical treatment the decedent received in 2017, 2018. Okay, you know what? Actually, thinking back, I think the judge did allow for discovery to continue come in up until the point of during voir dire, I think. Because I remember Mr. James wanted to, figure out what the deadline was for a discovery. And then the state said, there's a term that they use or a phrase that they use. It's like, once you have these people in, it's too late now or something like that. Oh God, I forgot what was the phrase that they use. My notes somewhere in my long pages of notes. But at first I thought it was like, once jury selection happens and no more discovery comes in. But now that I think about it, I think the judge allowed for discovery to continue coming in until they finally have their full selection of jury and then, opening statements and stuff. Okay, so tonight the state received 550 pages of medical records regarding medical treatment the decedent, George Torres, received in 2017 and 2018. The defendant acquired these records in January 2022. The state adopts all arguments and authorities cited in the state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force. The defendant, even in her most recent iteration of what happened on February 23rd, 2020, has not set forth the legal grounds to claim self-defense. Assuming that she does so at trial with a different version of events, ooh, that won't look good, then prior incidents of violence committed by the decedent that she was aware of would be admissible. Sorry, am I reading this wrong? Assuming that she does so at trial with a different version of events, which she might, then prior incidents of violence committed by the decedent, George Torres, that she was aware of would be admissible to show the reasonableness of her fear of imminent great bodily harm or death. Sorry, I don't have my glasses on. Number 6, these records are irrelevant. 487 pages regard an incident on December 24th, 2017, where the decedent was beaten so badly that he needed facial reconstruction surgery. Okay, so I remember one of the brothers that was interviewed did mention this. This is not relevant to whether the decedent committed a prior act of violence that the defendant was aware of occurring. If the incident that resulted in these injuries is somehow made relevant, the severity of the decedent's injuries is not relevant. If the severity of these injuries is somehow relevant, then the defendant should narrow down to the pertinent narrative history of what the decedent said happened and the treatment provided. This could be done in a handful of pages. The 2018 incident is also not relevant. The history provided by the decedent was that he put his hand through a glass window the day before, and his wife made him go to the doctor the next day. He received 2 sutures to close a 4.5 centimeter laceration. Oh, I wonder if George's daughters or if his ex-wife is going to testify. Assuming that the defendant testifies in a manner to make the incident relevant, a couple of pages of these records with a narrative of what allegedly happened, the treatment provided is sufficient to corroborate her testimony. Bearing the jury with 550 pages of records when nearly all of them are irrelevant when giving the defendant every benefit of the doubt on relevancy is unnecessary. God, poor state. And the probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading the jury, or needless presentation of cumulative evidence. Therefore, the state objects to these records barring their relevance being established at trial and their probative value not being substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading the jury, or needless presentation of cumulative evidence.
State's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
I'm surprised by that one. Medical records. Okay, what do we got here? George's medical
Just
records?
the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from 2 incidents, one in 2017 and one in 2018. A third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I've not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment, that narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well.
Are we taking Sarah's word for the incident with the brother beating him up? For the reason why it happened, yeah, I'm a little skeptical. But maybe they'll have that brother testify and talk about it.
They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages
Yes, Owens, we know.
of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages.
That was like 3 weeks ago. Are we going to whataboutisms now?
And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the
I
court right
understand
now.
that.
Yeah,
But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres' medical records prior to me sending them to you?
No, we didn't.
All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client, but a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres' medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that. But they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be...
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony...
You are the proponent of the evidence.
Yes.
So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages I think the state identified as that, what of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47
I
pages.
wonder if that's like a I don't know, but yeah, it'll be relevant when she testifies because I don't fucking know.
I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since we have some level of common ground here?
My case is not going to be presented, I would assume, until next week, so I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
That's another I don't know.
Position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them. But in one of the medical records, George Torres was over a .31 BAC. Every time.
In 2018?
2018.
I'm talking about the 2018 incident with regard to the plate glass
I have to
window.
look at the records. But there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a .3. When he gets over a .2 to .3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but, Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay. What about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find, based on that, whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be. Some of the records may be relevant, depending on Sarah Boone's testimony.
Something tells me he procured 550 pages of medical records and was like, you know what? Let's just submit it into evidence and figure out what sticks later on. And then the judge is like, okay, so what's relevant here and what's not? Well, I don't know, but, we'll find out when Sarah Boone testifies. Yeah.
About how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response.
Hello, Mr. J. Mr. Cacciatore chilling
The two parties'
today.
discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021, and they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them. And
The previous attorneys probably got those records and then probably thought it wasn't relevant, maybe. That's why it wasn't submitted.
were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case, or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both. And the state too, we both disclosed what are we actually introducing.
The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance, so I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you.
Maybe she wants to use it to say that, like, oh, you know, George was going in and out, post-op, pre-op, whatever. I was the one that was taking care of him. I'm the one that helped him heal. I was the one who was there for him. I made sure he did this. I made sure he did that. I'm the one who was the good in his life. I don't know.
But there needs to be something for you to link these documents together for me.
Next is the objections to the digital evidence, and the state, they kind of look just as confused as I was.
The objections to the evidence, or state's response to defendant's 5th amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
Yeah, me neither. I don't think it was mentioned in like defenses. I don't know. Like I didn't know what items 1, 2, 3 and stuff and all that shit was either. I was like, maybe it was in a different motion and I just need to refer to it.
It's tracking their 5th amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A, and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item tracking their 5th amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's 3rd amended exhibit list. When was the 5th amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left, so I'm not certain that they've filed anything with the clerk of the court.
Oh,
Here's the
no.
other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a one-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay, all right. I need clarification, Mr. Owens, as to when the 5th amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
Sarah, what are you doing? You leave that man's iPad alone.
You're asking for when it was filed. We're checking on that. When it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's 3rd amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Yeah, because I don't think I saw it.
Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else and let me get
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second.
No, I don't see Capsule back there. Oh, wait, that might be Capsule. Maybe her. So they will revisit it because there's some disorganization somewhere. However, here's some updates about the potential jurors. Seems like one of them got COVID.
I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID.
Oh, no.
And Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3, that would have been yesterday morning, seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around.
So after the break, here are the highlights of what happened afterwards. The defense is objecting to the state's digital evidence. The defense tried saying that these aren't relevant, they don't have dates, they're redundant. The state makes their argument, and we get to see what kind of evidence that the state has against Sarah Boone.
Judge, this was
Mr.
a little
Henderson.
bit of a new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence. The state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that time. Something might make something relevant at a certain time or it might not make it relevant. So there. And also as to just the foundational stuff, because the images, as I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd, 2020 date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before. Does that make it relevant? If it's 3 years before, I don't know.
What it has is what, and we were even so specific that we labeled one part of the PDF case-in-chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case-in-chief timeline count up as 80 photographs and videos. Attachments and rebuttal count up as 147 photographs and videos. There is metadata that comes with all those files.
That's what I was saying. I was like, there has to be metadata, unless it's missing the metadata somehow. I just wonder if maybe the defense didn't get a chance to look at it thoroughly.
So there is a date stamp and timestamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one might be 10/26/2019, 6:06 p.m. They all have file names. Providing context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this as states for the purposes of these hearings. So, for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is the case in chief timeline has a conversation that begins on Christmas of 2019, and it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boone, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th. Then it goes down to conversation that's going on January 12th into the 13th of January of 2020. Culminates in a text from the owner of the phone saying, "And bless you and all of you too, I'll get capitals rid of him." So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages. It starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of and there was problems with all the time. It's going to give some context to those things. It mentions when they became.
But how, I don't know. I guess like that's me just conflicts because she was saying that like she's scared of the family, what the family's going to do to her. But she was also going to the family to confide in them, at least like one of the brother, right? About George beating her. That's what she said. And that's the reason why George's brother fucked up his face so badly. That's all from her, right? Or she's trying to say that timeline is different. Like at some point I was confiding in them and then something must have happened and then they all hate me. I just wonder if she lied to them. I wonder if she tried to get the family to turn on George by talking bad about George and saying that she's like the savior. And then at some point the family caught on to like maybe her lies, or maybe they realized she was also the abuser as well, that it was also a two-way street. I don't know, because something must have happened. Like at some point it seems like based on what she said, she confided in one of the brothers, maybe the family. At some point they all fucking hated her and she was afraid of them. Wonder why.
Became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these time frames. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these time frames. We did our best to narrow it down to what time frames we set. We believe will give a good rebuttal picture after she testifies about his family and her relationship with him. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Ms. Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women. But I believe the context of those conversations makes it clear who was using the phone and who was not using the phone. So we believe.
Wait, is that why George doesn't have a phone? Because, wait, sorry, he said it so quickly. Is it because Sarah Boone was accusing him of, like, I don't know, porn and contacting other women? That's why he doesn't have a phone. I thought it was like maybe he didn't have a job and he couldn't afford the phone bill or something, and Sarah Boone was going to foot it or something. I don't know.
Judge, I think this procedure calls for a lot of speculation as to the defense part, as to what these photos, examples of the photographs, what's the use of this photograph? There's a piece of art on the wall. I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant.
Isn't that what the state and the judge argued earlier?
Then I have to form the objection. I don't think this is relevant.
What's your response to the lack of specificity? That these are just boilerplate objections to all photographs, all video?
Yes, well, they're not to all photographs and all videos. There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce. It is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge.
Or is it because the defense didn't have time to look through them, so they're just like, we're just going to object to all of it? What is going on here? I don't know.
I can't tell you what the independent objection would be. I don't know how it fits into their theory of the case. That's cause for me to speculate how it fits into their theory of the case. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, so they hadn't laid the foundation to get it in? It's putting the cart before the horse.
That pertains to the rebuttal evidence. What about the evidence that was outlined that the state intends on using in its case in chief?
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know? Guess what, Judge? The videos of the suitcase, we didn't object to those. Do you know why? It was clear. I know when it was, and I know the purpose of using it. But when you have animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that the state intends to introduce.
Correct.
Sounds like it covers the suitcase video to me. All means all.
The suitcase video is listed in one of the things that we don't object to.
I don't know that. I have image underscore 0954. I don't know what that is. Image underscore 0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well, what the state is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being omitted?
State conceded they need to lay the appropriate foundation.
Well,
Part of their argument.
okay.
So I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
And I have no problem with that.
Okay.
I have no problem with that part, Judge. The thing that I'm saying is, I want to make sure, because I didn't object to something on here, it waives my right to object to it later.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct. So I don't know what part I'm missing.
Anything else, sir?
Well, yes, Judge, I would like, because I know it's a different jurisdiction. People do things differently, okay? 30 years, I've never had to do this in a criminal case, okay?
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or last-minute issues. Then you all parachuted in on August the 30th.
Parachute in.
Yes.
There was no order, there was no request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Yes, sir.
But the reason behind that was because Ms. Boone at that time was representing herself pro se, and to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low. As to foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections, but as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly, but at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that. What my concern was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand. Any clarifications or questions with regard to the court's ruling?
We're just, I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or remove pages. That's all we're trying to do, is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Ms. Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Junella Wadden. And then Junella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day. And this is how Cellbrite works. This is my educational background, blah-bitty with this software. And I pulled this extraction out. Mr. J sent me this carve out of this extraction before trial. In fact, she picked it up yesterday. And I believe, you know, I'm going to testify that this is part of the larger carve out. This is from her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about this line of text isn't okay. This particular photograph's not okay for this reason. That's what we were hoping for.
Okay. Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge, this is the things that I reviewed. I sat down last night and went through every one of them preparing for this hearing. What we did not, or what we failed to do because of the time restraint, for the ones that we didn't list a number and I didn't give detail as to, like, IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection relevancy or objection foundation, then I'm not barred at that time.
But the state already said they need to establish foundation.
I don't know any rule that would bar me at that time.
Okay. I'm going to overrule your objections. For the reasons that I previously identified, you can raise your objections at trial if you deem necessary. But based on the state's proffer, I'm going to find that the different categories of documents that he's identified as reflected in Exhibit 4 are relevant. They are not repetitive. They are not cumulative. And so long as they can establish the appropriate foundation, and based on counsel's proffer, seems like they might be able to do so. Any questions, sir?
Now, I just want to add something for the record.
Yes, sir.
The state during its proffer said there were no photos of the child. That's not correct. There are photos of the child.
Okay, I see two images. I couldn't recognize it as a reflection of children in a, I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection to removing those two. I just didn't recognize it as children. I recognize it as a crab.
I haven't seen the picture, so I'm at a loss.
Well,
I'm sorry,
it's an
Judge.
extraordinary file name, but I'm going to remove those two
Okay.
exhibits that they're
I'll
talking
take care of that issue for you, sir.
That takes care of that issue, Judge.
Okay.
But the point that I'm trying to make with that and why I raised it is that there are going to be certain things that I'm not going to know into what is the purpose of it as far as how is it relevant now.
Defendant's fifth amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed.
Gummy bears, popcorn, gluten-free cookies.
It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour.
Lunch break.
My court staff does need a lunch break. So how do you want to proceed, Mr. J?
So the court decides to take a lunch break, and then they're going to continue on with the jury selection in the afternoon time. I think tomorrow morning is when they're going to continue making these arguments. So I'll see you guys tomorrow morning, bright and early. And then who knows when jury selection is going to be done, when opening statement is going to happen. I'm thinking maybe Friday morning, Friday afternoon, maybe Monday. Oh, God, I hope it's Friday. Do it on Friday. Let's do it on Friday. But, we never know what happens in jury selection. So we'll just have to wait and see. But, yeah, that was today's hearing. They covered a lot, and I'm tired. I'm going to go. But guys, I made a second channel for my YouTube channel to separate the vlogs from the true crime stuff. Feel free to check out the YouTube channel. It's called Hey Corgi-san. And then join the Discord if you guys want. Discord is a hangout place. We have a true crime section. Feel free to discuss true crime related stuff with anything that we're covering right now or other cases that you guys are interested in. And then we also have non-true crime stuff in there as well. All right, y'all. I hope you guys have a good one. Take care. It was a long one today, but I think tomorrow we're going to start off with Brian Boone's interrogation video, which is about 30 minutes. We watched a little bit of it today. I'll make a video putting it together. That way it's not separated in two different streams. So we'll start with that, and then we'll wait until the court is in session tomorrow for them to continue arguing these motions. Now, if anything changes, I'll let you guys know in the Discord notification, because I'm just trying to see when Law and Crime Court TV, when they're going to have their scheduled stream for tomorrow. All right. Have a good one. Bye.